Good morning, everyone, and thank you to Business Lincolnshire for inviting us to give this introductory webinar on intellectual property rights. Both myself and Deborah are patent attorneys from Potter Clarkson, which is an intellectual property law firm based in Nottingham. As a firm, we provide legal advice on all matters relating to intellectual property, such as patents, trademarks, non-disclosure agreements, litigation, and so on. So today, our presentation will cover the acquisition of intellectual property rights, followed by an example of how IP strategy can be implemented in your business. And we will also touch briefly on how IP can be beneficial for your business and give you some simple tips for protecting your innovations. So to start off, Deborah will give you an overview on patents and designs.
Thank you, Jason. I'm going to start off with patents, just to note as well that these different types of IP, some may be more relevant than others in your business, but it's important to understand the different types of IP protection, because what might be suitable in your business just now can of course change as your business develops and grows. So understanding what's out there, pitfalls, and how to acquire these types of rights is always useful. So I'm going to start off talking about patents. So patents are there to protect something with a technical feature, usually something that has a functionality attached to it. This could be the product or device itself, but it might also be a new method of manufacturing something. It may also be a new method of using something. It also extends to chemicals and pharmaceuticals. And it can extend to software. In the UK and Europe, software per se is quite tricky to protect, but if the software has some sort of functionality on a piece of kit or piece of hardware, then it's possible to protect that through patent protection. In order to get a granted patent, your invention must be novel and inventive over anything known worldwide before the filing date of your patent application. And your patent application will be examined on this criteria. Whether something's novel is pretty black and white. There just has to be one difference between what you are doing just now and what's been done before. Whether something's inventive can be a bit more of a grey area, and the legal test involves taking a notional skilled person, so somebody who's skilled in the field of your invention, and looking at whether he or she would consider it obvious to take the leap from what's been done before to what you're doing now. Because your patent application is examined for this novelty and inventiveness criteria, you might want to do some initial searching yourself to get a feel for what's already out there before committing to filing a patent application. You can use search engines such as Google, but Espasnet, and the website link details are there on the slide, is the European Patent Office website. It allows you to search for published patent documents worldwide by using a combination of keywords, and it will find patent documents that are published that have those keywords in the title or the abstract, and that gives you a good feel and a good flavour for what's already out there and what might be what challenges you might be up against if you were to file a patent application. Also, because your patent application is examined for this novelty and inventiveness criteria, it is very important that you keep details of your invention confidential until you file a patent application. That's because if you were to disclose details of your invention today, say on your website, and file a patent application tomorrow, that invention it's in the patent application can no longer be considered novel or inventive because it's already out in the public domain. If you do have to speak to somebody about your invention, so a potential investor perhaps, or a manufacturer, try and use non-disclosure agreements or NDAs. A firm such as ourselves, of course, can help you with these, and you'll also find some good sort of templates online. The UK Intellectual Property Office is quite good at providing things like that. Once you get a patent granted, it is a monopoly right. It allows you, as the patent holder, to exclude others from exploiting your invention. And certainly in the UK and Europe, that includes preventing others or stopping others from using your invention, keeping it, selling it, offering it for sale, or importing it into the country in which you have patent protection. You can be granted up to 20 years of protection from the date of filing your patent application, and in most countries there are annual renewal fees that you pay to keep your patent alive. If, say, 6, 7, 10 years down the line that invention is no longer commercially useful to you, then you just simply stop paying the renewal fees and the patent will eventually die. Oftentimes we come up against clients who, especially small or medium sort of startup companies, who are so busy and interested in getting their invention to market as soon as possible, which is understandable. They want to get the business going and start making revenue, that they sort of miss a trick in looking at what type of IP they might have and protecting that invention. Also, we often get experts in particular fields who, when they look at what they've done, think, well, of course that would be obvious because it was obvious to me to do that. Well, that doesn't always mean that it's obvious in the sense of gaining a patent protection for that idea. So these are some red flags that where you should be able to stop and take stock of what you've done through an R&D project before launching the product or service, and sort of think, well, have I done any of these, and is it then worthwhile seeking patent protection for the results? So of course, have you come up with something that you just haven't seen before? Well, that might be worth seeking patent protection. Have you put together 2 known concepts and found a surprising result? Or have you put together off-the-shelf components, so known components, but you've put them together in a new way, or so that they act in a new way, or so that they give a new output? Well, that might be worth seeking patent protection for. Have you had to put a lot of effort and design into getting round a problem with the result of that? Might be worth seeking patent protection for. And of course, have you improved or modified an existing product or manufacturing method? For example, have you made the manufacturing method more environmentally friendly or quicker or more cost effective? That might be a reason to seek patent protection. So patents are territorial rights. So if you want to prevent others from exploiting your invention in the UK, you need to have a UK patent. If you want to be able to do the same in the US, you have to have a separate US patent for the same invention. Australian patent, Chinese, etc. Excuse me. When thinking about what countries you want to seek patent protection in, you want to look, of course, first at your consumer market, where you're going to sell your product or service. Also, where are you going to make it, if that differs. And you might also want to look at countries where that type of technology is perhaps readily available, such that it might be a source of copycats or knockoffs. You might want to seek patent protection there as well. Some important points to note about patents that some people are usually quite surprised at. First of all, the application procedure from filing a patent application to get the patent granted typically takes around 4 years in the UK and most other countries. So it's not a quick process, and that's mainly down to the fact that the patent application will be examined, as I've mentioned, for that novelty and inventiveness criteria by the Patent Office. And that examination procedure can take a while. There could be a few rounds of arguments back and forth between the patent attorney and the Patent Office. And also because the type of right that can be granted for a patent can potentially be so powerful and potentially be up to 20 years, the Patent Office at least wants to try and make sure that they are granting a right that is valid, that is novel and inventive over anything known prior to the filing date. But don't worry, once you file a patent application, you are able to use that patent pending status or patent application number blah on all your literature, your products, your website, etc. And you get some provisional rights while your patent application is still pending. So once your patent application is filed, that's your stake in the ground, your filing date and your application number is given to you immediately. You can then go on to exploit your invention, sell it, speak to others about getting funding, etc. The patent system allows applicants to first file a patent application in their home country. So for us, most of our local clients will first file a patent application in the UK. You're then given 12 months to decide if you want to seek protection for that same invention outside of the UK. And this means that your later filed applications outside the UK, as long as they're filed within that 12 months, they what we call claim back priority to the first filed UK application. And that means that practically that it's as if those later applications were filed on the same day as your UK application. So you get a little bit of breathing space to file the first application in the UK, and you get 1 year to launch your product, start speaking to people, start deciding where it's going to be made, decide where your consumer market is, and perhaps also gain revenue from your product to help fund things like future patent applications or overseas applications. Or perhaps try and get a collaborator on board or a joint venture or a licensee that's going to help, again, bring you revenue and help fund your business, including the IP, overseas IP procedure. Worth noting that the current European patent system allows you to file a single application at the European Patent Office, and that application is examined by a single examiner. But once they grant a European patent on that application, you still have to cherry pick which countries, which European patent countries you want the patent to take effect, and there's usually a fee associated with that and perhaps some translations that need to be done. This European patent system is not an EU legislation governed legislation, if you like. So the UK will remain part of that European patent system once the UK formally leaves the EU. Also important to note that there's no such thing as a worldwide patent. So there's no such thing as a single patent that you can get that covers you for the whole of the world. You might have seen a PCT or WO patent application, or you might have seen documents with that sort of notation. That is a patent application procedure that effectively delays the decision of the applicant to decide what countries they ultimately want patent protection in, and I'll come on to that in a bit more detail in a second. Typical costs. It's quite difficult to put a cost on gaining or obtaining a patent because it does depend on quite a few factors, such as how complex the invention is, how crowded the field is, the nature of objections that might be raised by the examiner. But ballpark figure for obtaining UK protection, patent protection, we're seeing about £6,000 to £10,000 plus VAT. And that's spread over the sort of 2 to 4 years that it typically takes to obtain that type of protection. When you start looking at overseas protection, it's usually a little bit more, say £8,000 to £12,000 per country you want that patent protection in. And in some countries, especially ones that require translations, such as China, Korea, Japan, you might find that those costs start to creep up past the top end of that range. Okay, so as I mentioned, the patent procedure allows an applicant to first file in their home country, and it gives you 12 months breathing space to decide if you want to seek protection overseas. One way to do that is what we would call the direct route. So at 0 months, you've filed your UK application. 12 months down the line, say that you're in a position where you know exactly where your consumer market is, you know exactly where your product's being made, and you also have the funds to seek protection in all of those countries. Well, that's fine. At the 12-month mark, you file directly into each country you want to seek patent protection in. So say, for argument's sake, a European patent application, a Chinese, and a US patent application. Your UK application, the bottom line, will continue along its patent application procedure, so it will be examined for that novelty and inventiveness criteria I mentioned earlier, until you, say, 2 to 4 years down the line, obtain a granted UK patent. At the same time, each of your European, Chinese and US patent applications will also undergo their own examination procedure at their local national office, until, again, eventually you hopefully get a granted patent in each of those countries. The alternate route to this is what we would call the PCT route. So looking again at 0 months, you file your UK application. 12 months down the line, perhaps you've not had quite enough time to ascertain exactly where your consumer market is, or maybe you're not sure where it's going to be made, or more crucially, you simply don't have the budget to file in all the countries that you want to seek patent protection in. Perhaps you want to have a bit more time to try and either make more revenue from your product, or indeed get some sort of collaborator or joint venture on board that's going to help fund your patent application procedures. In which case you can file at that 12-month mark a PCT or WO patent application. So this effectively delays the decision that you have to eventually make for seeking patent protection in each country of interest. So it delays that decision by a further 18 months, and then that further 18 months down the line, you then decide, okay, I now know I want to file in Europe, China and the US, and I now have the funds to do that. So again, your UK application, that bottom bar, goes along its own examination procedure until you get a granted patent. Once the PCT application ends and you've processed the application into Europe, China and the US, each of those applications undergo their own examination procedure as before, until you hopefully get a granted patent in each of those countries. So this process is longer overall because you have the additional step of filing that PCT application. It's also more expensive overall because, again, you have that additional step of filing the PCT application, which typically costs around £4,000 to £4,500. However, for a lot of our clients, it's worth paying that money and having that delay so that they're in a better position at the end of that PCT procedure to know exactly where they want to seek patent protection. Regardless of whether you wish to seek patent protection or not, it's always a good idea before launching, particularly a new product, to have a look at any other existing patent rights that third parties might already have. You want to avoid the risk of basically having a nasty letter on your doorstep saying, I want you to stop what you're doing, you're infringing our patent. And we'd call this a freedom to operate exercise. So you can do some initial searching yourself, again, using search engines such as Google. This is where the SPASnet, that European Patent Office online website, is very handy because it is searching for published patent documents. Also have a look at competitors' products and websites. They might have marked their product literature and websites with patent pending or patent application number or patent number, and then use the SPASnet tool to go and find that patent document. But if you're worried about a patent document potentially having rights that you might infringe, then please seek professional advice from a patent firm such as ourselves. The question of whether your activity would be infringing someone else's patent rights is, as you can imagine, a very complex one, and it's better to spend a little money at the beginning to have that confidence and that comfort from a patent attorney about the risk of infringement than ploughing all that money into marketing and development and launching your product to then find out that you're actually going to have to pull that product from market because of someone else's patent rights. So I'm going to move on to a slightly different type of intellectual property right, and these are designs. So we've seen that patents protect a functionality, essentially, something with a technical functionality. Designs differ in that they purely protect the appearance of a product, so what the thing looks like. This obviously can include 3D objects, but it also extends to surface patterns and graphical interfaces. And there's some examples there on the slide. So bottom left, you can see a registered design filed by Kath Kidson Limited, where she's protected the surface pattern that she then goes on and uses on bags and homeware, etc. And on the right-hand side, you can see some more 3D objects that have had registered design protections, such as parts of a Dyson vacuum cleaner and the Trunky ride-along suitcase. For the design to be valid, the appearance of your design must be unique, but unlike patents, that uniqueness is not examined by the design office when you file registered designs, and I'll come on to that in a bit more detail later on. You can get UK design rights, and you can also get EU-wide design rights. Now, at this time, the EU-wide right is a single right that covers the whole of the European Union, and so once the UK leaves the European Union post-Brexit, the EU-wide right, design right, will no longer cover the UK. However, it's expected that any existing EU-wide right holders will be given a period of time to be able to carve out that UK part and have a UK right sitting alongside an EU-wide right. There are also registered and unregistered design rights, and I'll talk first about unregistered design rights. So these types of rights arises automatically once you do some sort of sketch that has an appearance, or perhaps make an actual 3D product that has a unique appearance. You might have unregistered design right in that. It is a bit more tricky and usually more costly to enforce than a registered right, and the main reason for that is that you must be able to show copying, and so it doesn't protect you against independent creations. So if you have an unregistered design right in a 3D object and a third party just happened to come up with something very similar, if you're not able to prove that they actually copied your design, then you would struggle to be able to enforce your unregistered design right. It also has quite a short duration, 3 years in the EU and 10 years for the UK. If we compare that to a registered design right, this is where we actually apply for a design right at a design office and get a design certificate. It is, like patents, a monopoly right. You don't need to prove copying, and it gives you the right to exclude others from exploiting the same or similar design. As I've mentioned, it is not a registered design application is not substantively examined at the design office, and this means obtaining that registered design is much quicker and much cheaper compared to patents. And there's some costs on the slide there. For the UK and EU as well, they also offer a system that allows you to file a bundle of applications at the same time and get cost savings on the second, third, and so on design. And this can be really helpful in sectors such as fashion. If you have a collection of garments, you can file designs to each of those garments on the same day, and you're not paying full whack for each application. So in the UK, say around £800 for the first design and only £150 for each additional. The maximum term of protection for EU and UK designs is 25 years from the date of filing, but the first renewal fee is not due until 5 years from filing, and that basically means that those costs on the slide, that's pretty much all the cost that you'll have. That's the cost of us helping you come up with a design filing strategy, filing the application, and it basically gives you 5 years free protection until you have to decide if you want to renew the protection. For a lot of fast-moving sectors, such as the fashion industry, after 5 years, they've moved on from that garment, and they just let the registration lapse. Also, unlike patents, there's what we call a 12-month grace period, and this allows designers to disclose their design, say today at a trade show, and it gives them 12 months to decide if they can still file UK or EU registered design protection. So it's a nice safety net if you have already disclosed your invention. We do, however, advise against using that as a strategy, because not all countries have this grace period, and so it might prevent you from filing design protection outside the UK and EU. And also, once you disclose details of your design, you start to lose control over what third parties do with that information, and that might of course come back to bite you in your designs. You also have 6 months from the date of filing to decide if you want to seek design protection outside of the UK and EU. So I'm going to pass you over to Jason now, who's going to go through trademarks and also round off with some advantages and top tips with IP.
Okay, thank you, Deborah. So, trademarks. Now, we're all very familiar with trademarks, and trademarks can be used to protect a brand. And for example, it could be the form of a word like Kellogg's, it could be a logo like the Microsoft or the Pepsi logo, slogans like Nike's Just Do It, or it could be in the form of color like the shade of green in BP's logo. It could be the shape of the Toblerone bar, or it could be the sounds of Intel or Direct Line. Now, the purpose of a trademark is to distinguish your goods and services from those of your competitor. So if you were to stamp your product with your trademark, that means customers, upon seeing that trademark, can feel reassured that that particular product originated from your business and not from your competitor. So how do you go about acquiring trademark rights? Firstly, you could acquire unregistered trademark rights through use of a particular trademark, so long as that particular trademark does not infringe upon the rights of others. You could also obtain a registered trademark, and which could potentially give you indefinite protection if properly used and maintained. So, with a registered trademark, you get a monopoly right, which is similar to patents and designs, where you can exclude others from exploiting your trademark. In order to get a trademark registration, you file a trademark application at the UK Intellectual Property Office in the UK, for example. And what the UK Intellectual Property Office will do is they will examine your trademark to ensure that it's distinctive in relation to the product, and make sure that it doesn't conflict with earlier trademarks. Once a trademark registration is granted, the term of protection is potentially forever, as long as you pay renewal fees every 10 years. Now, the benefit of having a registered trademark is that it is easier and more cost-effective to enforce, because a trademark registration is presumed to be valid, which means that the burden is on the other party to show that they do not infringe your trademark or that your registered trademark is invalid. So they have to take steps to show non-infringement or invalidity of your trademark. And also, registering a trademark means that your trademark goes on the trademark register, which puts the public on notice that you have protection for that particular trademark, which may deter people from copying your trademark. So trademarks can be obtained nationally. So you could have a trademark in the UK to get trademark protection in the UK, in France, and so on. And these are territorial in nature. So in order to get registered trademarks in different countries, you need to file different national trademark applications. You could get EU-wide trademark protection, but similar to EU designs, an EU-wide trademark registration would not cover the UK post-Brexit, but it is expected that it will be possible to carve out the UK right from the EU-wide trademark. If you require trademark protection in multiple countries worldwide, it may be advisable to file an international trademark application, and this may be a very cost-effective approach. The cost of filing an international trademark application will depend on the number of countries required for your trademark. So, cost of getting a registered trademark. For a UK trademark registration, typically, and this includes professional advice, we will expect the cost to be around £800 to £900 plus VAT, and this is for a single class. Now, the class of a trademark refers to the particular goods and services. So a class could relate perhaps to furniture, clothing, construction, telecommunications, computers, and so on. So normally you pick the class that is relevant to your particular industry. If you need protection across multiple industries and therefore multiple classes, there will be an increase in cost, but we will expect that it will be an extra couple of £100 per extra class. And the cost for EU trademark registration will typically be £1,800 to £2,000 plus VAT, and that's for a single class, and there will be additional costs for additional classes. Now, with unregistered trademarks, the cost of getting an unregistered trademark is pretty much non-existent, because as I mentioned before, you obtain unregistered trademark rights through use of the trademark. However, in general, if the trademark is important for your business, we recommend that you register the trademark. The reason for this is because it can be more difficult and costly to enforce an unregistered trademark compared to a registered trademark. As I mentioned before, with a registered trademark, the burden of proof is on the other side to show that they did not infringe or that your registered trademark is invalid. However, in order to prove that someone infringed your unregistered trademark, you need to show that somehow they are taking advantage of your goodwill and reputation by misrepresenting themselves as being part of your business or being associated in business in some way, and we refer to this as passing off. So in order to succeed in a passing off action, you need to prove several elements, and each of these elements require evidence such as expert witness statements, market research surveys, which can be very expensive. So in short, the burden of proof is on the owner of the unregistered trademark to show, and this can be very difficult and costly to pursue. And furthermore, unregistered trademark protection does not exist in some countries, so you may run the risk of having no protection in some countries if you were to solely rely on unregistered trademark protection in the UK. So when it comes to choosing a trademark, what you need to consider is, are you infringing somebody else's trademark rights? So what do? Now, this is similar to the freedom to operate exercise for patents, where you conduct trademark clearance searches. This may involve searching trademark registers, company names, domain name registers, or carrying out the searches under common law or relying on business knowledge. If you were to engage a lawyer to help you conduct a clearance search, typically it will cost £500 to £1,000 per country per trademark. Now, it is important for your trademark to be distinctive but not descriptive. For example, Google for internet searching, Kodak for cameras, Xerox for photocopying machines, Apple for computers, Orange for telecoms, and so on. Looking at the last example, you wouldn't be able to get trademark protection for the trademark fancy hats if you were operating a hat shop, or you couldn't have Cold and Creamy if you were selling ice cream. So you need to make sure that your trademark is distinctive in relation to the product or the service you're selling. The more unusual, the better. If your trademark describes the product or service that you're selling, it's unlikely that you get trademark protection for that trademark. So, and finally, it is important that if you have a trademark for a particular product, make sure that there's a generic way to describe the product. For example, escalator used to be a trademark in the UK, but at the moment it's no longer valid for trademark protection, because what they've done is they've marketed their product as an escalator, and these days escalator is the de facto standard name for a moving staircase. Had they marketed their product as a moving staircase branded under escalator, it may be possible that escalator will remain a valid trademark to this day. Similarly, we have aspirin and we have Hoover for vacuum cleaners, and we have Sellotape for sticky tape. So if you have a particular product, you got to ensure that there's a generic way to describe the product and make it clear that it is being branded under your trademark, and that your trademark is not the de facto standard name for your product. So now we've talked about patents and designs and trademarks, and so I will now discuss how this will fit into your business model. Now, I'll use the Dyson vacuum cleaner as an example. So imagine your business was based on the Dyson vacuum cleaner. So you've come up with some sketches of the Dyson vacuum cleaner, how it might look like and how it works. At this stage, it is important to keep details confidential, because as Deborah mentioned before with regards to patents, if you were to release information about your design or your invention into the public domain, it could adversely affect your chances of getting patent protection in future. So moving on, you make further developments to your design and you finally come up with a working prototype. So now that you have proof of concept, this is the stage where you consider filing a patent application, and you should be thinking about seeking advice from an IP lawyer. Once a patent application has been filed, you may decide to work on the appearance of the final product to make it more aesthetically pleasing for the market. And so although the function of the vacuum cleaner is essentially the same, the outer appearance will change. Once you finalize the design, which you feel is ready for market, this is the point you consider filing registered design applications, and again, seek advice on whether it's appropriate to file registered design applications. Finally, now that your product is ready for market, you launch a marketing campaign with perhaps a name for your vacuum cleaner and various trademarks. This is the point where you seek advice on filing registered trademark applications. And of course, at each step, you have your drawings, you have your prototype, you have your designs, and you have your marketing campaign with marketing material, technical brochures. All of that is subject to copyright, which is another form of intellectual property right. So, going back to the Dyson vacuum cleaner example, as you can see from the slide, there are 40 patents covering the vacuum cleaner, several trademarks, and several registered designs. What this does is it creates a ring fence around the Dyson vacuum cleaner, and it provides very strong protection for the Dyson vacuum cleaner. So if a competitor wanted to copy the Dyson vacuum cleaner, they will either need to design around each and every one of the different intellectual property rights owned by Dyson, or they will need to try and invalidate each and every one of these registered intellectual property rights, which can be very expensive. So the take-home message from this is, don't rely on a single IP right for your product if there are other existing rights. It could be that, from a typical product, you may be able to file a patent application for how it works, a design application for what it looks like, and perhaps a trademark for the associated brand. So, advantages of IP to your business. Why bother? First of all, as we discussed, registered IP protection can give you market monopoly, which will allow you to prevent others from commercially exploiting your innovation without your permission. IP rights is a form of property. It is something you can sell, so it is a form of asset. It is something you can mortgage, and it is something that you can license to others to gain income. As a third point, I thought I should talk about patent box. The patent box scheme is a government scheme that's been around since 2013, and what it does is, for products or processes protected in the UK through patents, it is possible to apply for tax relief based on profits derived from the patented product or process. Typically, you would expect to get a reduce rate of corporation tax around 10%, and this is something that you can discuss with an accountant, but it is important, you know, that you need UK patent protection in order to qualify for the patent box scheme. So, and moving on, having IP rights could help you attract an investor, get funding from an investor, or perhaps it could attract collaboration from someone interested in working with you. And without IP rights, it may be that they choose to go ahead with your innovation on their own, or they choose to work with someone else who has IP rights. And finally, IP rights could force your competitors to design around your invention or design, or it could deter them from copying. So it could buy you some time to gain a market lead while your competitors is busy trying to come up with a design that doesn't infringe your IP rights. So top tips for implementing an IP strategy: keep it confidential. This could mean that you may need to enforce non-disclosure agreements if you need to share the information with an external party, for example, a manufacturer or potential investor. If you don't keep the information confidential, it could obviously affect your chances of getting patent protection. Keep good records. Good records is very important, regardless of whether you opt for registered protection, because it helps you establish when you first created the invention, and this may be important in establishing whether you own the invention. Make sure you own the IP, because it may be a case that the IP was created by someone else, and if you were to commercially exploit that IP, you may be infringing their rights. So if you make sure that you own the IP, then there's no risk of infringement. Clearance searching or freedom to operate exercises is very important to make sure you don't infringe somebody else's rights. Having an IP strategy, which can involve registering IP rights or perhaps any of the above, including keeping information confidential, keeping good records, and so on. I wouldn't delay implementing your IP strategy. This is because the longer you delay your IP strategy, the bigger the window of opportunity for other parties to come up with an IP strategy that could basically be detrimental to your own business, because it may be that if you were to, for example, if you were to delay filing a patent application for your invention, it could be that another party independently comes up with the same invention, files their own patent application first, and suddenly your rights to exploiting your invention becomes severely restricted. So don't delay and consult an IP lawyer as early as possible. And if you have any IP rights, make sure that you monitor and use your IP rights, because there's no point in having IP rights if you don't actually exploit them. And finally, seek professional advice as early as possible. Most IP law firms, such as Porter Clarkson, will offer free initial consultations. So if you have any queries about intellectual property, you can send us an email or give us a call and ask to speak to someone, and we're happy to give you a free initial consultation. So that's it for our presentation, and I believe we can have a question session.
Yeah, it's just that.
Yeah, and I'll hand you over to Simon.
Thank you very much, Jason. Thank you, Deborah. Let's just see if we've had any questions posted during the presentation. We have a question here from Jane in Lincoln, who is asking, out of every 100 applications for a patent, can you give us a rough proportion as to how many would get through without very much additional work, how many would require significant additional work, and how many would fail?
Yeah, it's difficult. It's certainly very difficult to put a number on that. Another thing about the patent procedure is, of course, that it's not a guaranteed procedure. You're not guaranteed to get a granted patent at the end of it. How difficult it is to get the patent granted, again, will change from different fields of invention, different technical backgrounds of the invention, and also how crowded that field is. If it's a very crowded field, then there could be a lot of documents that the examiner cites against your application, and the more documents there are, the sort of stronger our arguments need to be against each and every one of those documents in order to get the patent granted. It's not unusual that our clients will file an application, start the search or examination procedure, and realise that it's actually going to be very tricky to get the patent granted. There are ways to sort of basically keep that application pending for as long as possible at minimal cost, and that's still very commercially advantageous to the client, because they can, while that patent application is still pending, they can still be marking all their products and literature and website with patent pending, patent application number, even though they know they're going to let the application die and not go to grant. There's that creation of uncertainty for third parties as to what type of patent rights you might be able to get, and again, a great deterrent factor for others. So number-wise, very difficult. It really varies on the client. They can decide to let the application die for commercial reasons. You know, they might be able to get a patent, but commercially and budget constraints mean that they let it lapse. But we certainly handle a mixture of people that definitely want a granted patent, regardless of the sort of scope of protection that we're able to get. For example, if they want to use the patent box, or there's people that want the broadest patent, and if they can't get that, they'll let it die. And then there's people that file a patent application knowing even from the outset that it's going to be really tricky to get it granted, but there's enough commercial advantage in having that patent pending status that they feel it's worth it to at least file the application and let it sit there for a good couple of years, even before you have to let the application lapse.
And I'll just add a short comment. I would say in our experience, it's rare that a patent application sails through with very little to no objections. In fact, if let's say once you file a patent application, you typically get a search report from the UK Intellectual Property Office. If that search report, normally the search report includes a list of patent documents of ideas which are similar or identical to your invention. Sometimes the patent office will list a series of documents, none of which is relevant to your invention, and essentially give you the all clear to get patent protection. Although that might sound like a good thing, sometimes it's not. That sometimes suggests that your patent application was too narrow in the first place, and therefore potentially you could have gotten broader protection. But having said that, I would say it's rare that patent application sails through. In fact, getting some objections might be a good thing, because it suggests that you were seeking the correct sort of protection. It may not be as broad as you like, but you'll be getting some form of protection. And in fact, usually when we draft a patent application, we will include multiple claims and multiple fallback positions. So even if the broader scope of protection fails and doesn't get through, you may get a slightly narrower scope of protection, which is still commercially useful for you.
Well, supplementary to that question then, Jason, following that, if you realise that perhaps you have applied in too narrow or niche an area, as a result of the searches that come back, and you want to widen the scope of your application, does that mean a whole new application?
That will depend on how the patent application has been drafted by people such as ourselves. So, as Jason mentioned, we would always try and initially claim the broadest scope of protection, so as to not tie you down to either it being used in a particular context or too many narrow features. Even if you're saying to us, well, this is how we're going to do it with feature A, B, and C, we might still look for just seeking protection for feature A and B at the outset, and keeping feature C, D, E, F, etc. as fallback options. If it turns out that either because of the search report showing that you've got the all clear, and so you start to question whether the application is too narrow, or indeed the business has slightly changed such that suddenly the patent application is a little bit too narrow for what they're doing, it will depend on what's in the application. Is there some wording in the application that says, yeah, we've said it could be this, but actually it could be all these other things? In which case, great, we can broaden it out. If there isn't anything in that patent application as filed, which it can happen, usually because the client's business has or the product has substantially changed since filing the application. If there's nothing in the application as filed to allow us to broaden that out, then yes, typically a new application is filed, and there's certain ways to do that. You can withdraw the existing application and refile, or you can file and do this claiming priority I talked about and add the new information. But of course, any new information that wasn't in the first filed application won't benefit from that earlier filing date. So that's one of the reasons that timing an patent application filing is quite tricky, because you want to, as Jason and I have both said, you want to get that application on file early, because you don't want to open up a window of opportunity for third parties to get in there first. But you also have to be far enough along your R&D procedure, if you like, to know enough that your functionality and the features of your product is not going to change. So it's a bit of a chicken and egg. But if you speak to a patent attorney or patent firm, earlier the better. The worst that can happen is we say to you, you've not got enough information yet, go away, figure out X, Y, Z, then come back to us. That's much better than coming to us too late and suddenly we're having to do a rush job, get it filed early, and you've also left this window of opportunity for others.
We have one more question already, and probably time for one more question. If you're watching this live and want to type into the question pane on your control panel, we've got time really for one more. So this may be the penultimate one of the last question. Realising that you're not either of your accountants, it seems that the patent box is almost reason alone to get a patent out of a project. How easy a scheme is that to draw down from?
Well, I'm not an accountant, so that's going to be quite a difficult question to answer. But the main step, essentially, is to have UK patent. It doesn't matter how broad or how narrow the UK patent is, as long as the scope of the UK patent covers your product or process. It could be really, really narrow or really, really broad. So probably a typical strategy for somebody intending to exploit the patent box scheme will be to apply for a patent by filing a patent application with a very narrow claim scope in order to increase the chances of getting patent protection really quickly, and therefore being able to take advantage of the patent box scheme. Now, in my experience, it is important to always try and protect a product in your patent application, because you will benefit more from the patent box scheme by having a product claim. It is still possible to benefit from the patent box scheme if you were to have a process claim, but in my limited understanding, the financial benefits is a lot less for a patented process as compared to a patent product.
Okay. Yeah. Well, thank you. There are no further questions, so it just remains for me to thank Jason and Deborah for their time, and I hope that everyone watching this has found that useful. Thank you for joining us. Please remember to register on the Business Lincolnshire website, where you'll find further details of forthcoming events and webinars, and enjoy the rest of your day. Thank you.